Sarah, over to you.
Thank you, Tanya, for that introduction. And yeah, if there are questions and I notice them in the chat, I'll be happy to answer them throughout the presentation. Please don't be offended if I don't notice it in the chat, in which case I will take any questions towards the end. Yes, good afternoon. So my name is Sarah Lowen, and it is my pleasure to be here today speaking on a topic that I find to not only be very important, but one that is also timely. Worker mental health is a growing area of concern for both employers and employees. And we see a lot more legal questions in the last few years that relate to questions from employers on how to navigate and manage situations of worker mental health in the workplace. So we know this is on the minds of a lot of people. Again, before I get started, I'd like to just thank and acknowledge WESC for providing these webinars. In the legal world, a current hot topic is access to justice, meaning that there is a lot of concerns about the barriers that many people face in gaining access to justice and legal services. So when organizations like WESC provide an opportunity for these types of presentations that address legal issues, this is part of what needs to happen in order to attain better access to justice. And I personally am in full support of that. So thank you, WESC. Also, before I get started, I would be remiss not to mention that, as you can see and have heard, I am a lawyer with W Law in Saskatoon. And although this presentation is not an advertisement for W Law, I will just mention that we are a full service law firm with lawyers practicing in many areas of law, including family law, corporate law, Aboriginal law, defamation, sexual assault law, and commercial litigation. The last thing I will mention before I get on with the presentation is that I do want to acknowledge that I'm speaking to you today from Treaty 6 territory and the homeland of the Métis. This acknowledgement is important to me personally for many reasons, but one of them being that I grew up in small town Saskatchewan and I was not taught to think about the connection between my own privilege, racial justice, and colonization. So I do make this acknowledgement as part of my commitment to seek to understand my place in current and ongoing systems of colonization and to recognize the rights of Indigenous people today. So just to give a quick sense of the scope of the issue of mental health at work, which I'm sure is no surprise, but Statistics Canada indicated in 2022 that about 18% of the population over 15 years old met the criteria for a diagnosis in the area of mental health. It's safe to say that many of those people are going to a workplace somewhere each day. And basically what these statistics tell us is it affirms for us that in today's atmosphere and growing awareness of mental health, that addressing and prioritizing mental health of employees cannot be an afterthought. It needs to be addressed front and center in workplace policies, and employers need to be intentional about fostering and establishing safe and healthy work environments. So although there are a lot of important reasons to take mental health of employees seriously, I'm a lawyer, and so we're going to talk about the legal reason why it matters. The legal reason why worker mental health matters to employers is that discrimination of an employee on the basis of a mental disability is prohibited under human rights legislation. So on the screen here is Section 16 of Saskatchewan's Human Rights Code, which states that no employer shall refuse to employ, refuse to continue to employ, or otherwise discriminate against a person or a class of persons with respect to employment or a term or condition of employment on the basis of a prohibited ground. I will note that, if some of you are considered federally regulated, there are similar provisions in federal legislation. So what is a prohibited ground? Well, again, within the human rights legislation, there is a list of what we call prohibited grounds. So discrimination of an employee on the basis of any of these listed prohibited grounds is a violation of the Human Rights Code. But obviously today we're talking about mental health, which falls under the category of disability. Under human rights legislation, disability is defined to include a mental disorder. So again, relying on the Human Rights Code, mental disorder is defined as a disorder of thought, perception, feelings, or behavior that impairs a person's judgment, capacity to recognize reality, ability to associate with others, or ability to meet the ordinary demands of life. Now, you might be thinking to yourself, well, that's a pretty broad definition, and you would be right. What actually qualifies as a mental disability within the meaning of the Human Rights Code is the source of a lot of debate in the legal world and in case law. So what actually qualifies, it is really all over the map in terms of what is considered a disability within that definition. And it has been interpreted broadly and what we call on the whole of the evidence. So I've listed on the screen a few examples of what may qualify as a mental disability within the human rights legislation. It's important to recognize, though, that symptoms of a mental disorder is different from an actual disorder that is considered a disability. So for instance, everyday stresses, sleep deprivation, or feeling a bit overwhelmed at work or something like that, that is different from an actual disability that would attract accommodations within human rights legislation or protection as a prohibited ground. So one key consideration in determining whether the condition or the issue is a disability within the meaning of human rights legislation is whether the condition is recognized by an accredited medical professional. And I'm going to come back to this topic of how you interface with medical professionals in terms of finding out if your employee has a mental disability within the meaning of the human rights legislation. But that said, just speaking generally, human rights law and employment law are areas that tend to really favor the worker, and employers are more and more expected to basically act as the front line for employees in navigating mental health concerns that affect, in particular, their job performance. So what I mentioned is, what if an employee is found to have a mental disability within the meaning of the legislation, and due to that mental disability, they are struggling with their job performance, accommodation of that employee is required. So what the law tells us is that there are three factors that we look at to consider whether or not accommodation is required. So the first step or the first factor is the employee establishes a protected ground of mental disability. So that's what I was just referring to. Do they actually have a mental disability? This is typically established, like I said, when employee presents medical information that provides evidence of a mental disability. If an employee says that they are suffering from a mental disability, then it is appropriate for the employer to request medical documentation to support this assertion and to help you understand better what is required to accommodate the employee. And I will come back to that again later. But as you can imagine, it's more difficult to establish the protected ground of mental disability as opposed to potentially other protected, prohibited grounds, such as like family status or something. So again, under step one there, a key point is that it is not enough for an employee to self-declare that they have a mental disability and require accommodations. The employer is entitled to more information in order to not only confirm that the employee does have a disability within the meaning of the human rights legislation, but also to know what sorts of accommodations might be required. So moving on to the second point there under step two, saying that there is an adverse impact on the employee at work. So this can refer to a number of different things, but for instance, maybe an employee has a sleep disorder, and so the workplace policy that requires the workday to start at 8 a.m. is adversely impacting that particular employee because they can't start the workday that early. It's too difficult for them due to a diagnosed sleep disorder or condition. Other, maybe more complicated examples arise where an employee is fired or dismissed from their job for reasons that relate to their mental disability. And where we see that more commonly is an employee just stops showing up to work. Maybe they're calling into work sick a lot, or they start showing up halfway through the day, or they go home sick. You're just seeing them not really attending work anymore, and they sort of start to fade away. And then eventually you say, well, you're fired because you're just never showing up. But if that absenteeism was related to a mental disability, that may qualify as an adverse impact on the employee due to the protected ground, which relates actually to step 3 as well. So the mental disability is a factor in the adverse impact. And this refers to the requirement that the adverse impact is actually related to the disability. So if you have an employee who stops showing up to work because they're suffering from, a diagnosis with depression or something, and they're fired because they're not showing up to work, that would be an adverse impact related to the mental disability. But if the mental disability has nothing to do with the reason they're not showing up to work, then there's no, it's not a factor in the adverse impact. So the third part of that test would not be met. So essentially, when employers call us and say, I have an employee with a mental disability, do I need to accommodate them? This is the test that we look at and assess the circumstances under. And when all 3 of these elements are present, then the employer is generally obligated to accommodate the employee to a point of what we call undue hardship, which I'll speak to more on in a moment. One other thing I just want to mention before getting on to this idea of accommodating to the point of undue hardship is that one of the ways in which that point of undue hardship can be reached is this idea of a bona fide occupational requirement. So what this refers to is basically there is a requirement for that job that can't be modified. It can't be changed. It's a hard and fast rule. And if that particular employee cannot fulfill that aspect of the job due to the mental disability, then that's considered, sort of undue hardship in that you can't change that piece of the job to accommodate this employee. So basically, a bona fide requirement is a reasonable limit on the accommodation. So it's where there's a standard or a rule, like I said, that's integral to carrying out the requirements of certain jobs. In order to make this claim, an employer must establish that any accommodation or changes to that standard would amount to undue hardship. So the Supreme Court of Canada did establish a 3-part test. Of course, it's law, so we love our tests. And that's the test that's on the screen to determine if that rule or standard is actually a bona fide occupational requirement. And I'll just give you some context to one of the key cases that established this rule because it's kind of interesting and it deals with actually gender discrimination, not discrimination on the basis of a mental disability. But that case dealt with a grievance by and maybe some of you have heard of it, a female firefighter. We call it by a female firefighter who had been dismissed from her job because she failed an aspect of what they called a minimum fitness standard. And that standard was established by the government for firefighters, saying this is the fitness standard that you have to attain in order to be a firefighter. In this case, that woman had successfully been doing the job of a firefighter for 3 years. Then the government adopted this new standard and series of fitness tests, which she failed. And so she was fired from her job because she no longer met the requirements of the job. She complained that that new fitness standard discriminated against her and women as a woman, and women generally, because women typically have a lower aerobic capacity. And so she argued that the standard discriminated against women. The government, on the other hand, argued that that fitness standard was a bona fide occupational requirement of the firefighter position, meaning that it was a requirement. It was a fair and reasonable requirement, and she couldn't meet that requirement, and so she lost her job. Ultimately, the Supreme Court determined that the new fitness standard was not a bona fide occupational requirement for a number of reasons, but including that the fitness requirement was not reasonably necessary to accomplish the work purpose of having firefighters who are physically capable of doing the job. And part of the reason they could reach that conclusion is she had been capable of doing the job for 3 years before the new fitness standard was implemented. So what they determined was that accommodation of women with lower aerobic capacity was not undue hardship. So back to the test and how, in relation to a case of a mental disability, step one of that test in whether we are able to determine something may be a bona fide requirement is to ask whether the rule was adopted for a purpose rationally connected to the performance of the job. So, for example, a requirement that a pilot have good eyesight, is that rationally connected to a work purpose of safe air travel? This would be different from a requirement, for example, that pilots have a shaved head, which may not be rationally connected to the job. Under step two is to ask whether the employer adopted the rule in an honest and good faith belief that it was necessary to the fulfillment of a legitimate work purpose. So here the employer must show that the rule is required because of a sincere belief that it is necessary to meet an actual business purpose. Basically, this is asking if the employer had good intentions, or if there's a chance the employer implemented that rule to basically push certain people out of the job, or unfairly bar certain people from having that position. And last step is to ask whether the rule is reasonably necessary. So under step two, we're saying, did the employer think it was reasonably necessary? And step three, was it? Is it actually necessary to the accomplishment of the legitimate work purpose? So that's sort of like an objective analysis. The main takeaway here, though, is that this is a high bar to meet. Employers should not consider job requirements or job descriptions as being a list of bona fide occupational requirements. No. Instead, job duties should be looked at closely with an open mind as to whether they are necessary for that particular position, or if there are adjustments that can reasonably be made. So, as I've said, employers have a duty to accommodate an employee to the point of what we call undue hardship. This definitely implies that the law accepts that for employers, there will be a certain level of hardship. Certain amount of hardship is acceptable and expected. So in our office, we are often consulted when an employer feels that they have already done everything they can to accommodate an employee, and that employee is still not performing their job, or is still struggling to attend work, or is still unsatisfied with the accommodations, and an employer doesn't know what to do at this point. So the answer to that is often found in looking closely at whether the employer has in fact accommodated the employee to the point of undue hardship. And again, this is also a very high threshold. Like I said, the law in these areas are favorable to employees, not employers. So figuring out whether an employee's accommodations rise to that level, that high level of undue hardship, is very fact specific. There are really no cookie cutter answers to that question. And the law, the application of the law will be different in every situation. But some of the factors that can be considered in trying to reach that determination are, like I have on the slide there, that health and safety considerations of the workplace and other employees, the impact of the accommodation on other employees, including morale or workload. For example, if you're a small employer and if you reduce the workload of one employee, does that unfairly impact all the other employees at your workplace? Those are the kinds of considerations that are perfectly reasonable to be made. And lastly, the cost of the accommodation. And the cost, we find often employers think any cost is, undue hardship. That is not the case. Costs for undue hardship need to be quantifiable. You need to show that you've made some calculations. You need to show if that is harming your legitimate business purpose. The Supreme Court of Canada, for example, has said that one must be weary of putting too low a value on accommodating the disabled. It is all too easy to cite increased cost as a reason for refusing to accord the disabled equal treatment. So that just gives you a flavor of how the courts will look at employers who say it's going to cost us money to accommodate this employee, we can't do it. They are going to want a very close assessment of what that cost actually is to you and how you reach that determination. So if there's costs, but some of the benefits will cover it, other factors, for example, projected, looking into the future, if there's going to be a bigger impact on your business or the employer. So you really have to take that analysis very seriously. It can't be that, well, this is going to harm me because it will cost me something. Again, the standard is much higher. So the obligation is primarily on the employer side to implement accommodations for an employee with a mental health disability, but not entirely. Okay, so employees have obligations as well. Employees must reasonably cooperate with the accommodation process. So if the employer is saying, I think we can try this, I think here's an option, if the employee is just simply refusing to try out these options, they have to have a good reason. They have to have a good explanation for that is related to the mental health condition. It goes without saying that often compromise is required. The employee will have to compromise. They cannot insist on their perfect solution. That's not the standard. And also, it is incumbent on the employee to advise the employer of exactly what are their capabilities and restrictions, because that's the only way an employer knows what kind of options might be reasonable to put on the table, is by knowing how that mental health disability is impacting that employee and what they can and cannot do within the workplace. I'll also mention, and again, it probably goes without saying, but employers who generally have a positive and good working relationship with their employees have a much easier time, in our experience, navigating the accommodation process, where employees generally feel respected, listened to, feel that their employer is sincerely trying to reach a reasonable accommodation. There just tends to be better cooperation, communication, and just overall an easier time reaching basically an agreeable solution for accommodating an employee. So just some general kind of summary comments on accommodating an employee that has a mental health condition. Again, the main obligation is on the employer, so you can't sit back and expect the employee to drive that car. You're in the driver's seat as an employer. Those accommodations that are presented and discussed should be based on the medical evidence. So you may have an employee who wants and desires certain things, but if it's not related to the mental health disability and the medical evidence, then those are not accommodations that need to be considered. And if there's any question about that, follow up for more medical information. If the employee is saying, no, this is part of my mental health disability, perhaps that's exactly the case. Let's get some medical documentation to support that. Be prepared to investigate a wide range of options and be very open-minded. One never knows what kind of out-of-the-box thinking, creative ideas might actually be the solution to accommodating an employee. And again, be prepared to modify rules and policies as necessary to make those accommodations. The courts do not look favorably on employers who are very rigid and saying, well, these are the rules. unless those rules go back to that idea of the bona fide requirement. And lastly, and I appreciate this can be frustrating for employers, but the duty is ongoing. So employers need to be prepared to have ongoing discussions, make changes as required. It's rarely, here's the solution, continue on working for the next 10 years and we never discuss this again. Those are regular ongoing discussions in the area of mental health disability. The needs of an employee can be changing depending on medications they might be taking, depending on their prognosis, depending on so many factors. So once this process gets underway, it may not ever really conclude, so to speak. So I also want to mention this other duty on employers. So this is what we call the duty to inquire. And this duty arises before the whole duty to accommodate to the point of undue hardship. This is where you suspect that you may have an employee who is struggling with a mental health disability, but they have not yet come right out and said something to you. So here, this is really what we call a procedural duty. This is a duty on employers to take certain steps before issuing, for example, any disciplinary action or terminating an employee where you suspect they may be suffering from a mental health disability. And this duty, which I'll explain a bit more in a moment, but it's really a way of preventing employers from claiming what we call willful blindness, or, you may have been observing certain concerning behavior, but later you want to be able to claim, well, they never told us, so we didn't know. That's really just no longer acceptable in the area of human rights law. You can't really claim we had no idea they had a mental health disability if you actually did observe signs that perhaps they did. So this duty arises for employees when there is sufficient indicia or indicators that an employee may need accommodation due to, again, any of the protected grounds, but including mental disability. So if and specifically if there are indicators that that mental health disability may be impacting their job performance. That is what triggers the duty to inquire. So again, some of those things you may observe at work can include like outbursts, missing a lot of work, calling in sick all the time, sudden changes to the employee's behavior or conduct, lots of crying or being suddenly very adversarial, that sort of thing where you think, is this a sign that this employee is actually struggling with something going on in their lives? And this could be, due to things going on at home, things going on right in the workplace, if there's issues around bullying, harassment, toxic work environment, any of these things, if the employer basically suspects this, the duty is triggered before issuing any disciplinary action. So just for instance, if an employee is chronically late for work and you suspect that they are impacted by a mental health disability, then the employer must inquire with the employee if they may be struggling with something that is impacting their job performance before issuing discipline for that lateness. So again, an employer has to be careful not to ask for too much information due to privacy concerns, but just having that conversation and saying, is there something else going on here that we don't know about that is impacting your job performance? Again, it is just really no longer acceptable within human rights law for employers to claim that they just had no idea when perhaps they did. So I'll just move on to a few practical tips, and then I don't have that many more slides here, so I'm happy to take questions. I'll check the chat and take any questions towards the end here. But just in terms of a few practical tips, Again, an employee has come to you, requested an accommodation for a mental health disability. What do you do? First of all, develop policies for handling these situations if you don't already have policies in place. That will really help you out when these situations arise, because you can then look at your policies, your employees can look at your policies, and everybody is on the same page about how to handle these kinds of situations. Next, and what should be written in your policies, is to investigate the nature of that accommodation that's required. That's where you say, okay, we're here to accommodate you as required. What exactly are your limitations and capabilities? Please provide us medical evidence so that we can start to discuss what are appropriate accommodations. And again, be willing to try a range of options and advice that lawyers give in just about every situation. Document, document, document. Document all your proposals, document how the employee has responded, document things you've tried. If they did not work, why did they not work? What was the outcome? Keep a record so that you can show, if needed, all the efforts and attempts you've made to accommodate the employee. Practical tips in another scenario where you suspect that employee has perhaps a mental health condition that is affecting the work performance. What should you do? And here, you know that you have an employee who is not performing their job to the standard that you want. Step one, keep it confidential, and that goes for basically dealing with any of these situations. Advise the employee of possible accommodations and any employee assistance program that they may have access to. And ask the employee about whether or not there are other things going on affecting their work performance in the context of a conversation about their work performance. So it's not appropriate for an employer to go around asking all their employees, do you have a mental health disability? No. It needs to be in the context of their job performance. So perhaps you're doing reviews or you've identified an issue and you want to address that with your employee and you suspect that they have a mental health condition or disability. That's the context in which you raise that question in order to satisfy your duty to inquire at that point. Again, this process is helped a lot if that individual having those conversations is basically sensitive and compassionate to the employee in how it's raised and discussed. So just some final thoughts here. Again, employment law and human rights law is very specific to every situation. Each situation is unique. There's always, different factors at play that form part of the assessment for any of the analysis and tests that I've discussed. And again, it feels like a cliche to say, but we do suggest getting legal advice and proceeding cautiously because the risk of a successful human rights complaint, like let's say this wasn't managed properly, and an employee does make a human rights complaint, the risk, if they're successful, and it's found that an employer has in fact violated an employee's human rights with respect to mental disability, can be very costly. Damages can include back pay for that employee in the case if they were fired, to the date of back pay to when they were fired, and reinstatement of that employee to their job. So the reason that can be very costly is because it does take a long time for human rights complaints to be resolved. And you could be looking at having to pay an employee who's found to have had their rights violated, 1 or 2 years worth of wages, plus giving them their job back. So it really is important from that legal perspective to take these issues seriously, proceed cautiously, and really act in good faith towards employees. That's something you want to be able to show that you've truly made your best efforts in handling employees who come forward with mental health disabilities. So that's really all I have to share with you today. So I see there are two comments in the chat. And okay, great. I don't think there are any questions. If any, I can give a moment if anyone does have questions. I'd be happy to chat, or if you want to reach out to me at some point and say, "Hey, Sarah, I attended your presentation. I have a quick question." I'm happy to take a few minutes at that time as well.